Alrighty, so I just started recording.
Excellent. And we are covering the last of four Supreme Court opinions that we've been covering in this almost last leg of our tour through political theory and philosophy. And we are dealing with the landmark case of Roe v. Wade on the issue of the criminality of abortion and related issues.
Indeed.
So, would you like to lead the way?
Yes. So I have the document open so we can kind of follow our references as we go through, because it's a pretty long document and there's a lot to cover. And yeah, so I guess we're dealing with...
Should we deal with the particulars, the specifics?
The particulars, maybe? Yeah. So we're dealing with the primary case being Roe v. Wade, but there's also some other cases that are involved with Halford and the Does.
Correct.
And yeah, so Roe is actually a pseudonym for a single pregnant woman who's bringing this action against the court in Texas regarding their criminal abortion laws. And yeah, do you want to go over some of the specifics? Because I have more for, I guess, after the specifics.
Sure. I think the specifics are a little bit straightforward.
Okay, that's fair.
It sounds that, I think we can sort of summarize. But this is, so obviously you have this pregnant woman, and I think what the reason that she actually has standing in the court is because at the time at which she filed the suit, she was pregnant.
Right.
Whereas with the
Does, yeah,
it's all sort of like
theoretical.
It's exactly. It's potential. Like they don't have children. It sounds like they're not even planning on having it. However, if they do, so that is actually sort of just like an interesting point, because the at least as the court sees it, they don't have standing because they're not actually dealing with the issue in the present. So basically, Roe, then back to Roe, she cannot have she does not have the freedom to have an abortion without, and this is key throughout this entire document, abortions were only allowed when there were issues of the health safety of the mother. So that was wrapped into the abortion laws in these states and specifically in Texas as well. But if she wanted to have an abortion for other reasons, that she was not allowed. She was not allowed that freedom.
Right, and I think I don't remember where this was cited, but she said she was unable to leave the state to go to another state that did allow that.
Yeah, I felt that. At least one part was there was a question of affordability. Like she couldn't afford she could go to another state that allowed it, but there was a question about her not being able to afford whatever, I guess, the transportation and transportation costs, and housing or whatever, to undergo it.
Right.
So therefore I should, it's sort of logic works, I should within my own state have the right to terminate this abortion regardless of health or life issues, right? Or not life, sorry, health issues, to the parent or the mother. I should be able to do this as this is part of my body, and we're going to get into the whole right to privacy element as it relates to this issue. But yeah, that there was that bit about her talking about going to another state that allowed it but not being able to.
So the Texas law begins on page 117, where it states in Articles 1191 to 1194, and it references those in the subscript here, kind of describing what abortion is and what the means and attempts are and the punishments for that, which also has some interesting things because it's not as long as the punishments are not as drastic as murder in that case.
Right. That is an interesting piece, and that'll pop it. That'll be a sort of consistent theme as they go through the sort of the genealogy of abortion laws throughout history.
Indeed. And then it states on 118, similar statutes are in existence in a majority of the states. So this isn't just a thing with Texas. It's a pretty
Very
widespread thing. And we're also going to see when we go through the history kind of how that adapted and became more either became more widespread or how it changed over time.
Yeah, it was interesting actually in the footnote on page 118, continuing into 119. I had just underlined each state. It was a lot of states. A lot of states. I don't know if it was. I mean, it was like majority. So I'm not sure who the holdouts were. Although I will say I didn't see Maryland in the list.
Is that right?
Just as sort of an example. Yeah, I mean, it starts with Arizona in that text, and basically all of the states are abbreviated.
Is it in alphabetic order?
It is. Oh, maybe. Yeah, maybe.
Okay. Interesting.
Actually, it is. It totally is. Yeah. So yeah, when you get to the whatever, let's say Maine, right, or after Louisiana, then you get Maine, and then Massachusetts, so on and so forth. I mean, I didn't go through each one to find out which didn't have a law.
Sure.
But yeah, so it was interesting that there were some that were. As a curiosity, it would have been interesting. And I'm not sure if I missed that because I wasn't reading all of the footnotes. If there was a footnote, sort of outlining the few states that were holdouts and what the rationale was, that would be interesting for further research.
Yeah, indeed.
But nonetheless, I mean, there are a lot listed in footnote number 2 on page 118 of all the states that have criminalized it.
Yes. Okay, so that kind of goes over a little bit of the law portion. If I guess in my notes, let's see. The next thing I addressed is on page 129. So I'm wondering if there's anything in between here.
I think it's sort of important to highlight that even though abortion sort of in general was criminalized, abortion as, and now I'm quoting on 113, page 113, the last sentence.
113 is.
Oh, I'm sorry.
Yeah.
119. 119. Okay. Sorry.
Yep.
Where it says that medical advice for the purpose of saving the life of the mother. So that's the purpose of saving the life of the mother is the one exception,
right? That
all of the laws are recognizing. Which obviously then you need to include, just as an important point. There has to be expert opinion here, expert medical opinion that would determine that the abortion ultimately is going to save the mother's life. So that's the one exception that we find. Even in the current laws in the early 1970s when all of this was being debated.
Sure.
So,
and then I guess from these pages, it's more just like the process of how, they're giving the pseudonym Jane Roe went about the federal action and kind of the reasons behind why she did that.
Yeah, exactly. You're looking at 120?
120, yep.
Yep. Mm-hmm.
And then the amendments that she brought forward.
Right.
So personal privacy protected by 1st, 4th, 5th, 9th, and 14th Amendments, which we'll talk more about, I think, 9th and 14th.
Yes. 9th and 14th were reiterated.
Yeah.
And then also, I thought this was interesting because this comes up a lot. There's the language is unconstitutional. That is to say, the Texas abortion statutes are unconstitutional, and then it also says that they're unconstitutionally vague, which is interesting.
Yeah.
That's obviously you can have a law that's sort of like crystal clear, and then you can also have a law that, if it is vague, could allow for X, Y, and Z.
Right. Yep.
Things that you aren't sort of anticipating.
Not specifying.
Just while we're on it, Christian, I think so. I pulled up the amendments. And we might as well just get these out just so we can sort of reference them.
Sure.
So the first one is obviously First Amendment. Congress make no law respecting the establishment of religion or protecting the free exercise thereof. It's the religion one, or abridging the freedom of speech. That I'm wondering if that's where we are, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So it's either going to, I don't see this as a speech issue, but I guess it's the latter part, the petition the government for a redress of grievances.
Mm-hmm.
So in other words, if the law was in some way, she felt anyway that she was being restricted from a petition, right? I guess that's how that's related in the first, but I'm not seeing how that's totally connected. 4 is search and seizure, the right of the person to be secure in their persons. Now that might be it. Houses not, papers not, effects, and against unreasonable searches and seizures shall not be violated, and no warrant, blah, blah, blah. Nothing else is, particularly describing the place to be searched and the persons or things to be seized. I guess that's an element of the right to privacy.
Yeah, like the unreasonable searches could be, it's like, randomly going into someone's house because, like, we know you're pregnant, want to make sure.
And the one thing we've been noticing about the Constitution is sort of, there is the law and then there's the extension of the principle.
Sure.
So this one clearly looks like, on the face of it, dealing with search and seizure of one's home, but it is talking about privacy.
Mm-hmm.
5th is rights of person. No person shall be held to answer for a capital or otherwise infamous crime, blah, blah, blah. Hold on. That's all sort of the right not to incriminate.
Deprived of life, liberty, or property, I think.
Yeah. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived, of life, liberty, and property. So
without due process of law. Yeah.
Yeah. So yeah, due process is going to be coming up in 5. I can see that. And then quickly on 9, this is unenumerated rights. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So so in other words, like, the rights that are not specifically addressed in the Constitution might still be there, right? And essentially, one can appeal to those even if they're not written per se. And then finally, the 14th is very long, but
I think it's only one section of the 14th. Was it the first? Probably the first one. I could be wrong though. Because the second one has to do with representatives and vice president. Yeah. Third one's senators, representatives.
Yeah.
Public debt. Congress has power to enforce
no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Oh, there we go again. Nor shall any state deprive any person of life, liberty, or property without due process. So it's probably going to be the life, liberty, and property, and the due process bit. Nor deny, because I think this came up, nor deny to any person within its jurisdiction the equal protection of the laws. Well, that one came up with Brown versus Board of Education. Totally.
Right. Also, to note, Section 1 starts with all persons born or naturalized in the United States.
Yes. Exactly.
Which is part of the language that we're going to be discussing.
Right. So you've got, so we can sort of, we've got those out there. It looks like on 121 and 122 you are dealing with the other actions, right? Dr. Halford, right?
Yes.
Who's sort of wrapped up in this, but not basically to put it in sum, he doesn't have standing either. So maybe we can jump to the heart of these issues.
Sure. Let me see if there's anything on the screen. So I think on 129 is where my notes pick up, and that's kind of where
That's fine.
it really gets
Let's jump there.
started into things where the section 5 starts.
No, that's good.
So here's where it reiterates the 14th and 9th Amendments,
Right.
and the right to terminate pregnancy. So yeah, it says Texas statute says that they improperly invade a right said to be possessed by the pregnant woman to choose to terminate her pregnancy. That's the language they're using here.
Yeah.
Personal liberty embodied in the 14th Amendment's Due Process Clause or in personal, marital, familial, and sexual privacy, as stated by the Bill of Rights. And then the 9th Amendment down here. So this is kind of what starts off the discussion, and then we, in the next section, which is section 6, it starts going into the history of the law, the common law's origin, which is very interesting that they chose to do that.
It is very interesting. I mean, this is when I told you whatever over the past few months as we were anticipating this, how interesting it was that they took a historical approach.
Yeah.
You know, I mean, and this goes back to what we were talking about earlier in terms of different in hermeneutics or interpretive modes of the Constitution.
Mm-hmm.
I mean, not totally, because obviously they reference Griswold as well, so that sounds like earlier precedents, you know, and then working with that, it's either they're going to agree with it or disagree with an earlier decision.
Mm-hmm.
But then this one is like just this massive historical sweep. And I wonder if the part of the rationale had to do with the fact that it was such a controversial issue, right?
Mm-hmm.
I mean, I would say that it was controversial in part because we have certain notions of what's going on in utero.
Mm-hmm.
And then also you have the majority of the states criminalizing a sort of non-medically related or, you know, life-threatening, abortion, right? So I wonder if it was sort of like, man, we better do our homework here. We better actually do the massive sweep to find out what views have been held in terms of what the fetus is. Is it a human being? Is it a person? When does it start? Things like that.
Mm-hmm.
Understanding sort of it's like it's a very sensitive issue. But you're right. Their approach is decidedly historical, and it raises sort of a question why they took that route.
Yeah, and I think you gave a good point. It's like they want to make sure they do their research, make sure they have kind of the history of how we got to where we are now.
Right.
But yeah, so they start in the ancient attitudes all the way back to the Persians and the Greeks and the Romans.
Yeah.
Mentioning that the Persians severely punished it as a criminal offense, and then the Greeks and the Romans not so much.
Not so much, yeah. It quote unquote, it was resorted to without scruple.
Without scruple, yeah. But the Greeks' opinions changed over time, we find out.
Yeah.
And the Romans, I guess, but through the Catholic Church. So yeah, they don't give too many reasons, I think, in this first section.
I think it's literally, that first section is literally like how X civilization punished it or not, how they legally dealt with it. So severely punished, not punished, like Greek and Roman, you know, so on and so forth. So it doesn't really sort of give the rationale.
Yeah,
you know, we get it with the Hippocratic Oath, but
which does prohibit it. On 131.
Yes, exactly.
There's a quote.
It's actually specifically.
Specifically.
like not just sort of in general, because there's sort of the general Hippocratic Oath that I think that doctors even to this day state as they're initiated, which that general one does not include it. It's sort of a general oath about protecting life and not harming life, but this is very specific.
Yeah,
right.
Very specific.
What was it? One of the quotes is Oh, yeah. I will not give to a woman. I'm not sure what a pessere is to produce abortion. Similarly, I will not give to a woman an abortive remedy. So and obviously Hippocrates is working within that in the ancient Greek culture. So we've got whatever. Let's say the general cultural attitude was less severe about it. However, within Hippocrates, and I guess his school, as it were, it's taken more seriously, far more seriously.
Right. It also mentions Pythagoras and dogma down here. So oath is not even uncontested even until Hippocrates' day. Only the Pythagorean school of philosophers frowned upon the related act of suicide, and then it continues. Where is that? For the Pythagoreans, however, it was a matter of dogma, for the embryo was animate from the moment of conception, and abortion meant destruction of a living being.
Right. And that's going to be in one of the cruxes as it relates to the status of the embryo, right? Is the embryo, actual human life, or is the embryo potential human life? But and that whole actual potential becomes really important.
Yeah.
Meaning, in other words, if it's potential, then it is not at that point. It does not have that. It's not at that point fully, right? Fully realized human being. If it was a fully realized human being, all of those sort of rights attached to a human being would connect to it. But if it's potential, it's not. Which is going to be a sticking point for the differing sides.
Sure. And then it continues to mention here, where is that? At the top of 132. No, wait, where is it? About the Greeks, I think they said something about viability.
Yeah, is that?
I think they reiterated that here.
I'm looking between these two. The first, let's see. You've got the first, as it relates to theories of the embryo and what it is. The first one, I think, is the one you just mentioned, right, about the Pythagoreans and the embryo. So it's animate from the moment of conception, and so aborting is destroying human life. And then on the next page, you don't, not in this Greek section. It's not until we get into common law the notion of quickening, right?
Yes, that's right.
But I'm trying to. You've got let's see.
On 131, it does say at the middle of the last paragraph. Most Greek thinkers, on the other hand, commended abortion at least prior to viability.
Viability, okay, and viability basically. So quickening. It seems to be sort of like, some of these terms are a little vague, but quickening seems to be the sense of movement within the uterus. And obviously the mother would know this probably earlier than it could even be felt on the outside, right? So that's sort of the quickening notion. So you're not going to feel that quickening like, day one, first week, so on and so forth. First trimester is probably like iffy. I don't,
Sure.
know when most women feel that movement. But then viability is the ability, and this is sort of interesting because I'm curious how they came up with the notion of viability in the ancient world.
That's a good question.
Because as you know, viability is basically the ability for the embryo / fetus to live outside of the womb, even if it is,
dependent.
Yeah, exactly. Dependent on some type of artificial machinery to keep it alive. Right. So, and I have no idea how they would have determined that in the ancient world.
Yeah, I don't know. Okay, so continuing with the history, we've got the common law, which it is undisputed that common law abortion performed before quickening was not an indictable offense.
There you go. And it gives us a nice little definition, right? The first recognizable movement of the fetus in utero.
Yes.
So,
usually from the 16th to 18th weeks, it says. Okay.
Not an indictable offense.
Yes, not an indictable.
Oh, I'm sorry. Yeah, sorry. Yeah, thank you. Yeah.
Okay, so that's the common law. Okay, I think there's immediate animation was also brought up here, which I think is is it just a synonym or just a similar term for the same thing?
Well, let's work through this because this is an interesting section. It says absence of common law crime. This was an absence of common law crime for pre-quickening abortion appears to have developed from a confluence of earlier philosophical, theological, and civic and canon law concepts of when life begins. These disciplines variously approach the question in terms of the point at which the embryo or fetus became, quote unquote, formed or recognizably human, or in terms of when a person came into being, that is, infused with a soul or animated. Let's see, so a loose consensus evolved in early English law that these events occurred at some point between conception and live birth. This was mediate animation. So I guess all of the above, right? Formed, recognizably human, person. If you use a religious language, infused with a soul, that is mediate animation.
Okay.
I'm guessing it's mediate because it's between conception and live birth.
Yeah, I think that makes sense.
Yeah. So, and then you get some specifics here, right?
You get a really bizarre view.
Oh God! Oh my gosh!
I don't know, ancient or older Christian theology.
Sure.
Regarding the fact that this occurs at different times for men and women, which is very weird.
Yeah. So I think we're actually roughly Middle Ages here for some of this stuff.
Okay.
Just looking at
do we have
the
footnotes for this?
We've got that. So we've got. Hold on. There's a Galen reference that carries over into some decrees that look like they're in the 1100. Oh no, that might not be 1100s. That might be the name of the law.
I don't see any references for this paragraph for the Christian theology.
Yeah, no, you're right.
Which is kind of weird.
Yeah. Yeah, I've got one. There's sort of one date around 1140 at the bottom of 113. I mean, they're connecting it to Galen's view. Galen would be more ancient, but this is like sort of an Augustinian notion. Augustine died in, I think, 425 BC, so it must have been his notion that was put into this codified in around 1140. So, point being, we're getting some medieval references here.
Okay.
But yes, the view of clearly there's a biased, sexist view of animation. We're looking now at page 134. Although Christian theology and canon law came to fix the point of animation at 40 days for a male and 80 days for a female, a view that persisted until the 19th century.
Now, what does that even mean back then?
You mean in terms of like how they came up with those days?
Well, no. Like, what do you do with that information?
Well, one, it's tricky to know. Let's say this is a reference to the Middle Ages. Okay?
Sure, yeah.
If this is a reference to the Middle Ages, I still don't know how they know whether or not you're dealing with a boy or a girl.
Exactly. So then you'd have to assume the shorter day, right?
unless they had sort of other sort of signs that we might say are, like bad science today. But if there were other signs that something else going on with the woman's body that would indicate that you've got sort of like a boy or a girl, according to sort of the science of the times, maybe like how is the womb low, is the womb extended, are there other things going on with the body that signal this is male or female? So if you have those signs in place, then you can say this is male or female, and then the female, fully animated at 40 days,
right.
Male fully animated at 80 days. Oh no, the reverse.
Backwards, yeah.
Yeah, 40 for male, 80 for female. I might be wrong here, but my sense is that fixing this, if one did have an abortion, it protects the men earlier, or if you will, the boys earlier than it would the women.
Yeah.
So that's where I see sort of a sexist element.
Absolutely.
But yeah. I think what's interesting is right after that, it says there was agreement, however, that prior to this point, the fetus was to be regarded as part of the mother, and its destruction, therefore, was not homicide. So that becomes really interesting. I mean, that's an interesting point. I know that in the area of bioethics, when the ethics of abortion comes up, this piece comes up. Like, in other words, this is obviously we don't want to say it's an organ, but we would say an organ is part of the mother's body. It is like an organ in that it is part of the mother's body. It is not like an organ in the sense that, it's going to change and develop and gestate and finally emerge, right, as a separate being. But yeah, I mean, it says like prior to this point. So that's going to be that's an issue to sort of kick around as well. Certainly, when we get to Aquinas, then we're Middle Ages for sure, right?
Right.
Yeah. So I feel like they're doing two things here. One is they're trying to figure, well, maybe multiple things, but more than two. They're trying to figure out what is this thing, and then they're also looking at how the legal cultures responded to it.
Yeah.
Right. So both of those elements seem to be at play. I mean, right. Like, I'm looking at the same page 134, the next paragraph. Whether abortion of a quick fetus was a felony at common law or even a lesser crime is still disputed. So they're looking at the legal component as well.
Yeah. And then they mentioned that it was had been. So Bracton thought it was homicide, but the later and predominant view following the great common law scholars had been that it was at most a lesser offense.
Yeah. So I think what we could say, at least up to this point, is that this is disputed, and yeah. I guess what in so doing their historical research, the Supreme Court is sort of trying to show that this is never in it. Let's put it this way: for a comparison, homicide most likely in all cultures. Right, so homicide, like unjustified killing, is a criminal offense, right? Yeah. But when you look at this issue, you don't have that type of universal response. You have pieces here and there, cultures, having different views of it, sections within that culture, individuals within that culture having different views on it. It's not the same,
Yeah.
I'm not saying that was their agenda, but certainly that. Could just be like pure historical research. Let's see what we find. But certainly you get that, right?
Yeah, and that's important because the United States is a large country with a bunch of different people and has many different cultures within it. So coming to a consensus will be important with that information.
Exactly. So English statutory law.
Yes.
It made abortion of a quick fetus a capital crime. But in Section 2, I guess, of this law, or this act, it provided lesser penalties for the felony of abortion before quickening. It seems like, at some level, like, the more it looks human, the further it is in its gestation, as it were. Because I'm certain by this point, what are we looking at? Yeah, 1803, we're I would imagine that within the medical schools, they've done their dissections. Do you know what I'm saying? They know what they know what, whatever. If a fetus or an embryo died in utero, I'm sure this was available for them to look at and analyze. So probably by this, the more it looks human, the larger it is. It seems like, okay, you're dealing with a human being,
right? And quickening again is the movement, so that would be like something that it initiates it on its own.
Right. Right.
So there's that kind of aspect of acting human.
Mm-hmm. Mm-hmm.
Oh, interesting. It disappeared, however, together with the death penalty in 1837. I didn't read that before. And did not reappear in the Offenses Against the Person Act in 1861. Interesting.
Yeah, I'm there. I'm here.
Yeah.
Just looking. Let's see.
We do get this Rex v. Bourne on 137.
I see it.
Which, let's see, what did I write? Oh, which brings up the notion of preserving the life of the mother.
Right.
And that's kind of where that phrase came up, I think, for the first time.
Yeah, I think you're right. Which I wonder if the sort of the progress of medical science was starting to realize that if a mother was dying, you know what I'm saying, in with child, if that was like, oh my goodness, okay, this is actually, you know, whatever, in so being pregnant, this can actually be lethal at times. This can jeopardize the life of the mother. It sounds like this is like a newer development. With that said, if it's a threat to the mother, then we can allow for this exception.
Right.
But you're right. We're not seeing that in earlier phases.
And this was in 1861. Oh, no, there's no mention in the 1861 Act. This was in the 1929 Act.
No. The exception from the criminal penalties of the 1861 Act.
He concluded in the 1861 Act the use of the word unlawfully imported the same meaning.
Oh gosh, yeah. Look, I mean that I'm sorry. That case, I'm sorry, is 1939. So.
Yeah.
Yeah.
So now we have this term, preserving the life of the mother. And that's where that came from.
Right.
Is there anything else before we get to the American law?
No, that's continue. It's continued because I looked under that act and it reiterates the same language.
Yeah.
Risk to the life of the pregnant woman. B. That is interesting. Actually, that is interesting. Let's not skip over that too quickly. So the Abortion Act of 1969, this is still English statutory law. The act permits a licensed physician to perform an abortion where two other licensed physicians agree, A, that the continuation of the pregnancy would involve risk to the life of the pregnant woman, or of injury to the physical or mental health of the pregnant woman, or any existing children of her family, greater than if the pregnancy were terminated, and B, that there is a substantial risk that if the child were born, it would suffer from such physical or mental abnormalities as to be seriously handicapped. So that's sort of a new piece, right?
Yeah.
Because the piece up to this point is what are the different views of the embryo? What are the legalities surrounding it? And then with this piece now, we've got something else. What if? Oh, I'm sorry. The next development, is the risk to the mother, and that now. By the way, the risk to the mother. This is sort of interesting in Section A, because you have. It's not just life of the pregnant woman, but it's also or of injury to the physical or mental health of the pregnant woman, or any existing children of her family, greater than if the pregnancy were terminated. And by the way, that seems like you're in a very I don't know how you judge that. Yeah, exactly. Like in other words, how are your physicians going to analyze that?
It's like
your way.
Yeah, your family.
It's a lot to weigh.
It's a lot to weigh because you're measuring the family as well. Because it's like, okay, all the children in the family. It's just not easy to measure, especially because both are potential futures. So how do you measure both?
Exactly.
So yeah, that's definitely a weird thing. It would be interesting to see any cases that were a result of that clause.
Agreed. And then B, and then the new development is the welfare of the future child. So if it had, if it were diagnosed having like spina bifida or something like that, like, they're not going to have a good life, and there's this whole sort of pragmatic element that plays into it. So in other words, would you have the right to, terminate if seriously handicapped, and they're allowing for it?
That's just bizarre to me. Like, I feel like this is just wrong on so many levels because, it begs the question of whether or not that would be allowed after a child were born, right?
Well,
like if you just discovered it after.
No. So you're performing the abortion,
right?
So this would be in utero. This is part of the act, the start of it. So it sounds like the determination would be while in utero.
No, I understand that the determination would be while in utero. It just begs the question. It's like you're determining the future of that potential life, right? And then if you take another instance where it's already happened and say you didn't observe in that state, it's that same potential future. It just seems absolutely.
It raises a lot of B raises a lot of interesting questions. I mean, the reality is this: obviously, if you have a quote unquote normal, healthy gestation, okay, and all signs are that this is a healthy embryo and a healthy fetus, then you can look to the future because we've seen it in the past. What will sort of result? You get this infant, it's healthy, they're able to develop into a child, and so on and so forth, and they're able to enjoy, all things being equal, a relatively happy existence. You could do the flip, though. I mean, you could do the flip, and you could say, what we have diagnosed. So spina bifida is horrible, right? And I don't even know what the well, there's a quality of life question because you have this malady, and then there's also longevity, like how long do those with spina bifida actually have to exist, right? But you can do the same because you can look to the past to see those that were born and what their life was like. Now, I understand that there's the question of, wait a minute, but this is you're talking about other than this major issue, which is huge, you are talking about a future human being, as it were. But I think that piece ultimately comes down to quality of life for the child, and then by extension for those who will care for the child.
Right.
And so it's, obviously if the child were born, then we have issues, right? You're not going to just terminate this baby because of the malady.
Right.
But, but are you, if it is a life of suffering, and if that's demonstrable in some way, would it be warranted? The
question would be, what's the difference of doing it right before or right after?
Sure.
Right. Sure. And that line becomes blurry, and then also it's like this is vague language as well. It's like, what determines a physical or mental abnormality?
Oh my God! No, I'm with you on that.
Yeah. So
what's interesting is that I think this opens up this piece. It's good we didn't breeze over this. It opens up the future law, or if you will, the ultimate opinion of this court, to the possibility that abortion is not only a life-saving device for the mother, right?
I don't think they actually incorporate anything of that in their final opinion.
No, I think you're right. I think you're right, because it ultimately comes down to like a question of, I think it comes down to a question of privacy, right? But I don't know. In my mind, it opens the way for more than just this one piece about saving the life of the mother.
Mm-hmm.
There are other factors in it, but you're right. In so many words, they're not alluding to it.
Right. Okay. American law.
Mm-hmm.
Okay, so we're at 138, 139. So it kind of picked up from the English common law.
Yeah, which makes sense.
Which makes
right?
sense.
Mid 19th century, 1800s. What were they to appeal to?
So,
a lot of those laws continue in.
Yeah, Lord Ellenborough's
carryover.
Act, quick with child, death penalty was not imposed.
Mm-hmm.
Abortion before quickening was made a crime in that state only in 1860.
Mm-hmm.
The includes New York.
The New York one is interesting, right? So the New York law, 1828, while barring destruction of an unquickened fetus as well as a quick fetus, it made the former only a misdemeanor, but the latter a second-degree manslaughter. So you can see this slow development, although I think it really gets pushed, to be honest, with the American Medical Association on page 141. We don't need to jump there,
right?
But that when I read that, I was like, oh wow, like this group had a very clear view, and it looks like they were able to lobby enough for all the states to fall in line.
Mm-hmm.
That seemed to be, but nonetheless, you do have, prior to that association, you do have the carryover of the law, and then at least with Connecticut, New York, they mentioned Texas as well.
Yeah,
starting to develop their own laws that are, let's put it this way, let's at least say at this point they're not as freewheeling as ancient Greece and Rome.
Right. Mm-hmm. And I think wait, where is that? Oh, yeah, 139. Gradually in the middle and late 19th century, the quickening distinction disappeared from the statutory law of most states, and the degree of offense of the penalties were increased. So we see this increase in the penalty and the distinction. So the end of the 1950s,
the quickening's sort of gone.
Yeah. A large majority of the jurisdictions banned abortion, however and whenever performed, unless done to save or preserve the life of the mother.
Yeah.
So again, picking up off.
No, that's true. So in a sense, by the 1950s, right?
Yep.
So that means, that's fair, because actually I was going to say maybe there was already a change within the culture about it, and then the American Medical Association sort of picks up on that, but actually they meet in 1857. So I still think that association had a lot to do to change views, because it's 1800s, and the reference you just gave was by the end of the 1950s, a large majority of the jurisdictions banned abortion, except for preserving the life of the mother.
Yep.
This one's a good one too. I think on 140, it is thus apparent that at common law at the time of the adoption of our Constitution, so it's key there, right? What were views surrounding on abortion around the time of the Constitution, and throughout the major portion of the 19th century, abortion was viewed with less disfavor than under most American statutes currently in effect. Phrasing it another way, a woman enjoyed a substantially broader right to terminate a pregnancy than she does in most states today. So that's sort of an interesting piece surrounding the time of the writing and adoption of the Constitution. But it's 141, the American. I mean, I was just like underlining everything here. I don't know if it hit you as well, but that I was like, oh wow, this is a group, medical professionals, who are, or it even says as well, it says, indeed, the attitude of the profession may have played a significant role in the enactment of stringent criminal abortion legislation during that period. So we're in late 1800s, And that's basically when this association comes together to quote unquote investigate criminal abortion, quote, with a view to its general suppression. It deplored abortion and its frequency, and it listed 3 causes that we can reference or not.
Mm-hmm.
But so let's say, for instance, that this medical association really did have some pull. There are 2 things that come to mind. Either they did their homework and therefore resolved that actually, this is a living being, so on and so forth, or they had that view and basically used their power to persuade. Do you understand?
Right.
In other words, someone can have a view without doing the research, right?
Sure.
You could just end up having an opinion on something, and so that was the thing in my mind. And 2, you're talking like the 1800s. That we're much more. I mean, we're not skeptical, but we certainly don't have a paternalistic view of doctors like you would have had in the 1800s. Sort of like, oh, doctor knows best. They're the expert, so on and so forth. I think we, in our quote unquote postmodern times, have much more of a sense of questioning. And well, that's true actually with the vaccinations, right? Anti-vax people, right? Mm-hmm. There's a much more questioning culture now. But I would imagine if you had a medical association, then I mean, it's sort of like word of God almost.
Sure.
So, yeah. I mean, even some of the language, widespread popular ignorance of the true character of the crime. That the fetus is not alive till after the period of quickening, so they got rid of that notion. So I would imagine they saw it alive at birth, or I'm sorry, at conception.
Wait. I see.
Yeah, and then second of the agents alluded to is the fact that the profession themselves are frequently supposed careless of fetal life. And third, grave defects of our laws as regards the independent and actual existence of the child before birth as a living being.
Mm-hmm.
So I feel there's a massive moral tone to this. I mean, and actually that's not, I'm not saying that's wrong, but it seems more of like the moral tone than, let's say, a philosophical, scientific tone.
To what, the AMA?
Yeah.
Okay.
And I don't think that that's unfounded, as even they called it that, this general demoralization. So it raises the question, to what, again, to what degree were they doing sort of pure research and then giving their findings, or they just basically had their view and disapproved of most people's or a lot of people's views on abortion and quickening and things like that,
Mm-hmm.
So.
Oh yeah, and then on top of 142, the committee then offered and the association adopted resolutions protesting against such unwarranted destruction of human life, calling upon state legislatures to revise their abortion laws. So this seems to be something that contributes to what we just discussed a minute ago.
Yeah, and very interesting. I forgot this piece when I first read it, but it does go to show sort of the role that a let's say a professional group or professional assembly can have in a culture in terms of helping alter views and also laws. I mean, it seems like this was no small association.
Sure. Yeah. Is there anything else here? Because we also have the American Public Health Association.
Yeah, I'm sort of so this is 1970, right?
Yes.
I mean, this is right on the nose because I think she files the suit in 70 or 71.
So these are more of like what the standards are for the services. So like a rapid and simple abortion referral must be readily available through state and local public health departments. An important function of counseling should be provided. Psychiatric consultation should not be mandatory, which is interesting. Wide range of individuals from appropriately trained sympathetic volunteers to highly skilled physicians may qualify as the counselors. And then the contraception and or sterilization should be discussed with each patient.
Yeah, so, it doesn't seem like it really comes down. It seems like more process, right?
Yeah, it's more like what they're currently requiring. Yeah. And I don't remember too much from the American Bar Association.
I had referenced the footnote.
Oh, the Uniform Abortion Act?
Yeah, where it looked at section 2 of that. Within 20 weeks... sorry. I mean, it's middle of the sentence. Well, that's fine. Within 20 weeks after the commencement of the pregnancy, or after 20 weeks only if the physician has reasonable cause to believe, 1, there's a substantial risk that continuance of the pregnancy would endanger the life of the mother, would gravely impair the physical or mental health of the mother. That also is open, but life makes sense of the mother. That the child would be born with grave... There it is again. The child would be born with grave physical or mental defect. And that the pregnancy resulted from rape or incest or illicit intercourse with a girl under the age of 16. So you've got... but what was the status of this? This is the Bar Association.
House of Delegates approved within 17 opposing votes.
I think this is also full margin. I still think that that's not a law, right? This is an act. This is an act agreed on by those within the association.
Yeah,
this is no different than the the 2 earlier associations. It's just legal. Yeah. Which, by the way, is interesting because the first one clearly has a moral stance on it. The second one, like, pretty much banning all forms other than the risk to the life of the mother. The second one, so the one we went over, as we said, is more process than substance. And then this one is certainly open to other forms of abortion other than just life-saving.
Right.
So.
All right, so that's the history.
That is the history. My goodness, that was long.
So now we're on to some of there's a couple. I still have so many notes. We're halfway through my notes right now.
Yeah, I would imagine. So I've got time. So
okay, cool.
If it's a long one, it's a long one.
That's fine by me. So I'm just going to highlight kind of the high levels of the notes that I have, and they kind of go sequentially with the rest of the documents. But we have right to privacy. We have the kind of... So right now we've got the history, but we have the Supreme Court's kind of discussion on beginning of life and personhood discussed in the Constitution. We have the state's interest in protecting life. And then we have kind of the conclusions of the assenting opinion, and then we have the dissenting opinion at the end.
Correct.
So those are kind of... Like, I have a bunch of notes on the beginning of life and personhood, but we can start with right to privacy, which I think picks up on page
151.
151, 152.
Yes. Okay. Yeah. 152, you're right. So, so there you have, as it says, Constitution does not explicitly mention any right to privacy, but the court has recognized that a right of personal privacy or a guarantee of certain areas or zones of privacy does exist under the Constitution. But so the question then is, and there's more discussion of it in Section 8. And actually sort of like, I'm sorry, maybe some of these things should be highlighted. So it's not explicit, but it is guaranteed, by extrapolation. and then it's apparently been applied to like personal privacy, a guarantee of personal privacy as it relates to marriage, and then they list a case, procreation, and they list a case, contraception, and they list a case, family relationships, and they list a case, and child rearing and education, and they list 2 cases. So you're sort of getting this trajectory, right?
Yeah.
Of there does seem to be this thing called personal privacy. This thing called personal privacy does relate to things that are intimate to us: marriage, family, procreation. Mm-hmm. And the question is going to be, how ultimately does the question of abortion wrap up into this, right? So yeah.
So here in
153. Yeah, that's key. Go for it.
This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, or as
that's key. This little phrase, as we feel it is.
Yeah. Or
that's the court's, yeah.
As the district court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy.
That's huge.
Yeah, it's broad enough to cover that. Which is
we can talk. We probably should pick away at that a little bit. But before we do that, mm-hmm. let's just hit the next section, because I've highlighted some things. So the detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Mm-hmm. Specific and direct harm medically diagnosable even in early pregnancy may be involved. Maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. Mm-hmm. So you've got the latter part's very pragmatic, right? Or I'm sorry, utilitarian, right? The whole notion. Remember, utilitarian ethics. Yep. Increase the pleasure, decrease the pain. Mm-hmm. So it's very utilitarian, and I'm guessing it's getting wrapped up into privacy. I sort of want to throw in there a little bit of life and liberty, right?
Yeah. Mm-hmm.
And pursuit of happiness.
Mm-hmm.
Because if the happiness at some level is being restricted by having this child, then one of our whatever fundamental rights is being being restricted. So and that's a problem. But I think what's really interesting here is this, and I have it like asterisked and underlined and highlighted, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Let's sort of tease that out.
Sure.
What do you think?
Wait, so this is if we go back to the amendments, this was for the ones we were just looking at, the 14th and 9th?
14th and 9th. And I've got them up here.
Yeah, me too.
Yeah. So the 9th, once again, is unenumerated rights. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Okay, so that makes sense, because for these things that are not explicitly stated in the Constitution, right, which we're talking about now, is a right that is to be retained by the people, and I guess also deferred to the state, right?
And I would agree with the court that it is broad.
It certainly is broad, yeah.
Very broad.
I mean, it covers everything not explicitly stated.
Let's put it this way.
Yes.
It's not only broad, but let's put it this way. It could encompass a woman's decision whether or not to terminate her pregnancy, right?
Yeah.
Meaning, in other words, it's broad enough to cover something that's not explicitly addressed in the Constitution.
Yep, that makes sense.
And then 14...
Section 1, I think we're still mostly dealing with.
Correct. I just want to go back there. 14th Amendment's concept of personal liberty and restrictions upon state action. So, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Okay, so like obviously there are other examples that we would entirely agree with.
Yes.
Right?
So I think in that statement,
Mhm.
the privileges or immunities of citizens of the United States, and I think the argument that they're having here is that, particularly with the less stringent rules on abortions towards the beginning of the Constitution, these were privileges and immunities that the citizens of the United States had. So it is covered within that.
Right.
Now, of course, there's the nor shall the state deprive any person of life, liberty, or property. That's going to be more conflicting with kind of this idea of the beginning of life and personhood when we get to that.
Right. Which they do address, and I thought was really interesting in terms of how, like, whether or not you can really impute personhood on, and let's do it this way, the constitutional notion of personhood, because that's the framework here.
Yeah.
The constitutional notion of personhood on to embryo or fetus, right?
And we'll get to that at 157.
Personal liberty will become an issue. We can look at this in two different ways: personal liberty as it relates to the embryo's own personal liberty, personal liberty as it relates to the mother's own personal liberty.
Yep. And the state's vested interest in both of those.
Exactly. So the reality is this: it seems like you actually first need to establish whether or not the woman's decision to terminate, whether or not to terminate her pregnancy, is a personal liberty, or I'm sorry, a personal liberty, or falls within the category of right to privacy. And then after that, once that's determined, then you'd make this move on the restrictions upon state action, right?
Right.
It seems like the one needs to precede the other. Because you have to, because in other words, you can't say the state has restricted my right to do X unless you've established the right to do X.
Right.
Right. So, and in my own thinking, I want to try to understand the justices, and then do my own response to it. So, but if we do the understanding, just the analysis, like. I'm still trying to get the rationale of how this falls within issues of privacy, personal liberty, etc. Because it seems like you're already making a decision about the embryo. If you say that this is within the mother's personal and private rights, then it seems like you are already saying, to determine whether or not she wants to terminate, it seems like you already are making a conclusion about the status of the embryo.
Yes, and that's what the district court is doing, right? That's what it says in that first sentence, that the district court determined. And then at the beginning of the next sentence, it states, on the basis of the elements such as these, appellant and some, is it amici or amici?
Amici, yeah.
Amici,
or if you do the medieval amici.
Amici, okay. Argue that the woman's right is absolute.
Actually, I think it's amici. Sorry.
Okay.
Yeah.
That the woman's right is absolute in that she is entitled to terminate her pregnancy at whatever time, in whatever way, and for whatever reason she alone chooses. With this, we do not agree. So the reasoning for the Supreme Court, it follows in this paragraph. I guess the district court, like, there's not too much about the reasoning from the district court's opinion on that amendment and why it's broad enough to encompass it.
Right. I do think so. So in other words, it's not absolute, right?
Yes.
It's not an absolute right.
No,
because
yes,
they're putting restrictions on when you can have the abortion.
Right.
Right.
Yes.
Which is going to be whatever, first trimester or something like that. So they even continue that 155, middle of that paragraph, first top paragraph, the privacy right involved therefore cannot be said to be absolute. An unlimited right to do with one's body as one pleases bears a close relationship to the right of privacy previously articulated in the court's decisions. And then we therefore conclude that the right of 154.
Yeah.
We therefore conclude that the right of personal privacy includes the abortion decision, but that this right is not unqualified and must be considered against important state interest and regulation.
Mm-hmm.
So the state interest and regulation, just to be clear there, would be
the state's interest in the mother's life, in the fetus's life, and in how it goes about. So regulation would be like what physicians are allowed to do the operation, and like any kind of other regulations that would go about around that.
Mm-hmm. Mm-hmm.
And we're going to get like more of the details of that in their final conclusion.
Sure.
But yeah, I think so. What they're saying is we conclude that the right of personal privacy.
Actually, to your point,
yeah,
on the bottom of 155, not the very bottom, but almost, it says at some point the state interests as to the protection of health, so here we have state interests, medical standards, and prenatal life become dominant. We agree with this approach at some point. And I'm guessing at some point we're talking second and third trimesters.
Yep.
Right.
Mm-hmm. Okay. Let's see. Okay, yeah, and right after that, fundamental rights are involved. The court has held that regulation limiting these rights may be justified only by compelling state interest, and they list some other cases, and that a legislative enactment must be narrowly drawn to express the legitimate state interest at stake, which narrowly drawn, I guess, could be an issue with the vagueness clause.
Mm-hmm. Mm-hmm.
Let's see.
I think it's interesting. It's on 156, like right after Section 9, right on Section 9. It says the district court held that the appellee failed to meet his burden of demonstrating that the Texas statute's infringement upon Roe's rights was necessary to support a compelling state interest, and that although the appellee presented several compelling justifications for state presence in the area of abortions, the statutes outstripped these justifications and swept far beyond any areas of compelling state interest. So
did I lose you?
No, I'm there. Just trying to make sense of that a little bit.
Was necessary.
So this is interesting.
Go for it.
No, I think you're on the same one. The state's determination to recognize and protect prenatal life from and after conception constitutes a compelling state interest. So their interest in doing that's compelling. As noted above, we do not agree fully with either formulation. And then you get into this where you get into personhood in subsection A of Section 9. The appellee and certain amici argue that the fetus is a person within the language and meaning of the 14th Amendment.
Mm-hmm.
If this suggestion of personhood is established, the appellant's case, of course, collapses, which is true. For the fetus's right to life would then be guaranteed specifically by the amendment.
Mm-hmm.
On the other hand, if the appellee conceded on re-argument that no case could be cited that holds that a fetus is a person within the meaning of the 14th Amendment. Then you get into sort of this question of sort of personhood. I think what is interesting in this case is everything we were talking about, sort of about state's interest, right?
Yes.
That's an interesting piece. So the state has a vested interest in, let's put it this way. Ideally, the state would only restrict where restrictions are constitutionally warranted. And the question is then, is this restriction for the freedom of Roe to have an abortion or not? Is that restriction, constitutionally grounded? Right. So that's an interesting piece because it's not just sort of about, let's put it this way. It seems like if you have, so it comes back down to personhood, because I mean, as it even says that we just quoted, if the fetus is a human life and therefore is a rights bearer, right? Then the state would, by default, have an interest in protecting that life, therefore restricting abortion.
Yes.
Right. With the exception, that we know, the one exception, but and so it seems to still surround personhood a little bit. We're not going to say that but obviously, if it's not a person, if it's not a rights bearer, then you're restricting the mother from doing something to her body that she should have the freedom to do. So it comes down to, what is this thing?
Yeah, definitely.
Which they get into.
Yep. 157, the Constitution does not define person in so many words.
Yeah.
So work needs to be done. Then what they reference where, like, basically all of the places where person is referred to in the Constitution.
The conclusion is basically the bottom of that, right?
Yes.
That person is defined postnatally.
None indicates with any assurance that it has any possible prenatal application, right?
Yeah, exactly.
In nearly all of these instances, the use of the word is such that it is applicable only postnatally. So nearly all. There are some that it could.
Yeah.
Which I guess the 14th Amendment parts of the 14th Amendment could be included in that, like the life, liberty, and property, right?
Right. The next section above says, all this together with our observation, supra, that throughout the major portion of the 19th century, prevailing legal abortion practices were far freer than they are today, persuades us that the word person, as used in the 14th Amendment, does not include the unborn. And then they list their cases.
And we're actually going to run into something interesting from the dissent on this particular notion,
right?
Which we can get to when we get to it, or we can jump to it now.
We can jump there now.
Okay, so I think it was page 174.
Okay. I'm there.
Yes.
So, sorry, just to give context, Justin Rehnquist was one of the dissenting, and this is now being drawn from the dissenting, not the majority opinion.
Yes, and so on 174, the second paragraph, the fact that a majority of the states reflecting, after all, the majority sentiment in those states have had restrictions on abortions for at least a century is a strong indication, it seems to me, that the asserted right to an abortion is not so rooted in the traditions and conscience of our people as to be ranked as fundamental. Snyder v. Massachusetts. Even today, when society's view on abortions are changing, the very existence of the debate is evidence that the right to an abortion is not so universally accepted as the appellant would have us believe. And that's important because in the page that we were just on, 158, they're saying, hey, it's a new trend, and when the 14th Amendment was created, this wasn't something that needed to be regarded, or wasn't something that was common, when in fact it really was more common than they're kind of saying, I guess.
Yeah, I think so with that,
I guess right before this paragraph he says something about partakers more of judicial legislation than it does of a determination of the intent of the drafters of the 14th Amendment. I feel like there's something more here. Basically, like, it was a large enough concern that it wasn't necessarily ignored in the 14th Amendment.
Yeah, I think they're making a historical argument as well. I think this This is sort of tricky ground.
Sure.
Like the latter part that you read, I think, to reach its result, the court necessarily has had to find within the scope of the 14th Amendment a right that was apparently completely unknown to the drafters of the amendment. But you have to be like, isn't that so separate from the abortion question?
Mm-hmm.
Isn't that what we've been calling the genius of the Constitution? That there would be things that within the Constitution that clearly the drafters wouldn't have foreseen. I mean, let's say something like, I'm trying to think of something analogous that like dealing in high tech or something like that, where you've got this you've got laws related to tech companies. If you had something like that, right, which you do, I just can't pull it forward. You're going to, I mean, that couldn't have been foreseen. Maybe the principle could be foreseen, you know, a basic principle. But I thought, I think I mean, I don't know. I think if you find something within the 14th Amendment or within the Constitution that's completely unknown to the drafters, I don't know how strong of an argument that is.
Sure. I mean, that's not his conclusion.
No, true. But I mean, but it's, I don't know. Let's see.
Well, I think what he's saying is that it wasn't completely unknown, right? Whereas the appellants are saying that it was, or
no, this one's no. He's saying the court, and I believe he is. I could be wrong, but I believe he's referencing the majority opinion.
Yeah.
Necessarily has had to find within the scope of the 14th Amendment a right, so the right to privacy, ergo the right to a free abortion, that was apparently completely unknown to the drafters of the amendment. And now I will grant, well, no, that was a different amendment. I thought it was search and seizure now. But I don't know, my sense is that if you throw in the 9th Amendment with the, you know, unenumerated rights, that's almost by implication showing already that the drafters were at least open to the idea that they hadn't covered all of the rights.
Oh, I think what he's getting at here is that, wait, so the majority opinion, right, that was apparently completely unknown to the drafters of the amendment. Then he continues by saying, by the time of the adoption of the 14th Amendment in 1868, this is going to 175, there were at least 36 laws enacted by state or territorial legislatures limiting abortion.
Right. Sure. Right. So he's basically essentially making that when a historical and cultural argument that when it was drafted, the broader American society and legal system had already, you know, had a ban against abortion. So meaning, in other words, those drafting it most likely held that opinion on abortion, anti-abortion, and did not foresee that the 14th Amendment was including that right.
Right. The only conclusion possible from this history is that the drafters did not intend to have the 14th Amendment withdraw from the states the power to legislate with respect to this matter. So basically he's saying it's not in conflict with the laws already there at the time. The state laws already there at the time. Right?
Yeah.
Okay.
Yes.
Which, I mean, that makes sense.
Go for it.
No, I was just saying it makes sense that, like if there were conflict, it would be addressed.
Yeah. But also, I mean, here's the other thing too, and he does mention it in terms of like society's changing views on abortion. You know, so he sort of addresses that piece. But one of the reasons that let's put it this way, it wasn't a well, it wasn't a controversy in the 1800s like it was a controversy in the 1970s.
Right.
So if it's not a controversy in the 1800s when the 14th Amendment was adopted, then it's sort of like it's a non-issue. It's a non-issue to even sort of like bring up and foresee and include in the 14th Amendment. But I feel like the whole nature of the Constitution, and we include the amendments by default,
right,
as a part of it, is that there's an element to it that legislates specifically, and then there's an openness for extrapolation for future generations, and if you will, application that its literalism might not include. Do you know what I'm saying?
Right.
So the yeah, I mean, it ultimately, you know, I mean, at some level comes down to a question of sort of interpretation.
Yeah, I mean, it's,
you know,
I forget which, was it hermeneutical? Is that were those the words
yeah.
we were using?
Mm-hmm.
Yeah.
Yeah.
Which one we were using, or he would be using, because he's comparing the laws of the states to the law that was enacted, or the 14th Amendment, which was enacted, and saying, hey, they weren't in conflict then, so they're still not in conflict now.
Right.
Whereas the majority of the court would be saying, hey, it is in conflict, and I guess more so by the raw text of the document, it's in conflict.
Yeah, I mean, he's going. There's going to be a bit of textualism and a originalism element, right? The textualism looks just at the text. The originalism is looking at the text and intention, right?
Yeah.
And so that's clearly what's going on. This amendment was drafted at this particular time. The predominant view on abortion was, against abortion, or against free abortion, as it were. Ergo, that intention needs to be wrapped up into the meaning of the 14th Amendment.
Yeah.
It can't be included. You can't include something like the notions of privacy that wouldn't include this.
What's very interesting here is that so it's a historical argument, and
yes,
the majority of the majority of the court is using a historical argument for determining, well, not entirely, but for determining what's going on with the situation. So he's kind of following their same logic, in this case. Whereas, and he's applying it to a specific part, whereas they're using it kind of in a different way. And they're kind of using the textual definition for the 14th Amendment in particular, which is the same thing that, was it Frederick Douglass did in Brown v. Board? And that worked. Like, we're looking at the text and only the text in plain English. So that's just an interesting distinction.
I think, you know what I think? I actually think there is so much ambiguity in this approach.
Yeah.
And so much that is unclear. And by approach, I'm sorry, with both the majority and the minority, or the dissenting opinion.
Sure.
Because, and to be fair, it's sort of no one's fault. Okay.
Yeah.
Because the Constitution prior to the Bill of Rights and amendments, there's a specific focus, and that's and the specificity of it is brilliant in terms of outlining specific things like the three branches of government, right? And other features related. It's very specific, but then, as many texts are, there's an openness of interpretation on particular pieces: life, liberty, pursuit of happiness, right? I mean, those are big, broad terms. We have a general sense of them, but not it's hard to delimit them, right?
Sure.
And so I want to say it's no one's real fault, because the drafters, so the founding fathers drafting the Constitution, they just weren't anticipating this question.
Mm-hmm.
Because if they were anticipating this question, I think they probably would have included it either in the body of the Constitution or within the Bill of Rights.
Sure.
So because it's not explicit, it creates this problem then for both sides as they try to apply, Roe's case to the Constitution,
mm-hmm.
and amendments. So it's, both the majority and the dissenting opinions, they're using sort of a historical approach. They're using a precedent approach as it relates to prior cases. They have to get sort of philosophical, as it were, on the question of personhood, as we already talked about, right?
Mm-hmm.
And how are you going to do that? I mean, because personhood itself is so, and I mean this in a good way, philosophically vague. What do you lean on? Well, you've got to, you can lean on a lot of different things, right?
Mm-hmm.
But you're also going to lean on the Constitution.
Yeah.
And so that's what the majority opinion does. They go back to the Constitution. Great. Well, what's a person in the Constitution? It doesn't seem like it actually argues, at least in most cases, for a prenatal person.
Why don't we go back to 159, 160?
Yeah.
And continue.
But are you with
that?
me? Like, there's an element here that I feel like, because there's so much that is vague and so little that is explicit.
Mm-hmm.
It makes the whole project and work of answering this question definitively and clearly a challenge.
Absolutely. Yeah, like the Constitution was made to be vague in certain regards. Like,
right.
Forget which amendment was it? Was it the 19th?
Yeah.
No, which one was it?
9th? The enumerated rights?
Oh, yeah, 9th, right?
Yeah.
Yeah.
Or unenumerated, sorry, unenumerated, right?
Yes. Yep. Where it allows for, like, it defers the judgment to the state and then to the people, where it's not explicitly stated, right?
Yeah.
But yeah, why don't we go?
What?
I
got something where we might be going to the same spot. I'm not
okay.
Sure.
I was going to say, why don't we go back to 159, 160 and continue
Perfect.
the personhood discussion?
Perfect.
Okay.
I think at the bottom of 159 is really interesting.
Yeah.
So real quickly, we're just going back to the majority opinion, and within the majority opinion, this was they're just addressing this question of personhood. Okay.
Yes.
At the bottom of 113, it says Texas urges that apart from the 14th Amendment, life begins at conception and is present throughout pregnancy, and that therefore the state has a compelling interest in protecting that life from and after conception. Very interesting comment, which is next. We need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at a consensus, the judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer,
mm-hmm.
which obviously we would agree with this opinion as it relates to this one piece, that all these respective disciplines can't arrive at a consensus.
Right.
Right. Now, the other piece is, are they still nonetheless not playing by the rules of their game, because they are allowing Roe, right, or any woman, let's say, to choose to abort regardless of health reasons? Is that still not, like, in other words, we're not answering this question. We're not actually coming down on this question. We can't come down on this question. However, we're allowing a woman to have the right to abort in the first trimester. There's part of me that thinks, like, in other words, I agree with the first part. It is vague, right? How is a cluster of cells a human being, right? I get that. But the piece that's tricky is that as soon as you allow for her to choose to have an abortion for whatever her own personal reasons are, aren't you sort of coming down on the question of at least what it is in the first trimester?
Right.
I mean, you're saying that it's not a human life. It is not a person. It's not a rights bearer, because if it was, you wouldn't allow her to do it.
Right. Yeah,
That
it does
that
sound
piece
like
to me,
a contradiction, or at least an excuse.
Unless I'm missing something, because if like, in other words, it's sort of like we've got to deal, like, in other words, it's a big question mark, and until that question mark is answered, right? Because it doesn't even say that. It sort of, I mean, it hints at that, right? At this point in the development of man's knowledge, it is not in a position to speculate as to the answer. So the question is while it's a question mark in that, let's just say, first trimester, why would you allow it, or why would you disallow it?
Sure.
I mean, both are warranted, because if it is a human life, then you know what, and we were to determine this centuries later, whatever, then, I mean, there's a lot of murder that's gone on. If it isn't a human life, at that point, well, if it isn't a human, I mean, it's the question mark problem piece is the part that I have a problem with.
Yeah, it's kind of like they're putting a Band-Aid on the issue, like, oh, well, we can't speculate to the answer, so we're just going to come up with this to make the average people happy or whatever.
But I
which is kind of utilitarian, right?
Yeah, I mean, I agree with the fact that it's vague.
Yeah, absolutely.
And they're being honest about that. But that next step is sort of the tricky part. Why would you, I mean, as I already said, if you allow it, you are sort of already assuming what it is,
Yeah, and I think, I don't remember the exact reference, but earlier in the document, they did say that, like, this kind of a case is special because it's regarding pregnancy, and because the term is shorter than some cases are resolved. It's like,
correct.
There's, that aspect to it. So maybe, they're trying to come up with an answer. Or at least a solution, maybe not the answer, but a solution. Yeah, so I guess on 160, it should be sufficient to note briefly the wide divergence of thinking, this most sensitive and difficult question. So they bring in these beliefs to show what they're saying is that they don't come to a consensus.
They don't come to us. Yeah, two things go on there. So in other words, once they say that, there is no consensus, what we just quoted on 160, you're absolutely right. It goes right back to sort of, all right, listen, from all these different historical perspectives, we have trouble sort of defining it. We're not in agreement. We're not in consensus, such that. And
they reiterate a bunch of these points from historic.
Correct. And then, in short, so 162, bottom up, the unborn have never been recognized in the law as persons in the whole sense. So from these historical pieces, right? And actually, to their point, because there's the whole question of viability. Well, then they weren't, prior to viability, a full person, otherwise you'd protect them, or quickening, so if no consensus, we can't say that they're persons in the whole sense. And I think the whole sense is key there. There's something going on. They even say that new embryological data that purport to indicate that conception, 161, is a process over time rather than an event.
Right.
So here's the other issue, and I think it's really interesting on 162, section 10. In view of all this, we do not agree that by adopting one theory of life, Texas may override the rights of the pregnant woman that are at stake. And maybe that's the issue. Like, in other words, there is no consensus. Texas is taking a position to override the right of the pregnant woman. So if there's no consensus on this and no agreement on this, and we're unclear on this, why does Texas have the right to make a position on it? That part I also get. So the part that I have with the problem with the majority opinion is you allow it. You were still saying at least indirectly what it is. But then the flip side is, well, Texas is taking a stance on what they think life is and when life begins. What's your argument? I mean, you know what I'm saying? Like, are you just stating that? If you're just stating it starts at conception, but what's the argument to back that up?
Right. Like they can't just take a view and not back it up.
Right.
And then go from that point.
Especially after the court's already sort of outlined all of these divergent views.
Right.
So that and maybe this is sort of like more legal argumentation than it is necessary. I guess what I'm sort of saying is like, you are restricting this person's right without full whatever. This is a two-step process, and the second step is obviously restricting this person's right, or not right, sorry, freedom to do X. Okay, because we're establishing it, I guess, in this case that it's a right. So the freedom to do X with their body. So that's what you're trying to do, but you haven't even done the work of establishing the first step.
Right.
And that is that this is actually a living being from conception to live birth.
Right.
I agree with that. You can't just stipulate it. So, if whatever, you were able to make the argument, so on and so forth, and that was to be, we review that. Then once that's established, then fine. Step 2 is allowed,
I did want to bring up one thing about viability, if you don't mind.
Sure.
Which is like the question of like this disparaging view between, or I guess when you're talking about viability, right? You're talking about existence outside of the womb. You have to take into like the context of what that means, because is one life deemed more viable than another, even if all other conditions are the same? So if you take into account technology that can preserve life outside of the womb, then does that mean that someone who is wealthier and more able to afford it would be more viable? Or by location, because it's readily accessible nearby, that life would be more viable? And I think that these kinds of issues are probably going to become more prominent in the future when the technology advances.
Yeah.
And one kind of argument for determining that life begins at conception is it's taken by both politically left and right people, I think is important to state. Like, famous people like Jordan Peterson, and then you're probably not familiar with Destiny, but he's a famous debater on the internet. They both agree, that like it's really hairy of an argument to try to determine the beginning of life, which is what the Supreme Court is determining here. And that it's safest. What they believe is that it's safest to assume the beginning point of that process, which is conception. But Destiny backs this up with that doesn't necessarily follow that you come with like a Kantian perspective of all abortions are illegal, because there are so many different things that go on into it, and like what does it mean that if it's illegal from the very beginning? It's like, well, now the U.S. has a huge problem to deal with. And how do you even start? Like with the context of what's been happening over time with all of the current abortions, and then it's impossible to regulate, right? Almost virtually impossible to regulate, which is a problem. So which is interesting that these people may come to the conclusion that life begins at conception, but not necessarily be able to support in entirety that from a legal perspective that you can protect it from the beginning.
No, that I would certainly commend its subtlety. I think I mean, it sort of sounds to me like it's a safe bet or position to hold, because we know at some point this cluster of cells is going to end up looking like one of us, right? So it's sort of like, if you can't determine it in the first trimester, is it quickening, is it viability, so on and so forth, and these are all sort of like vague terms and there's nothing concrete about it, then why not just go safely back to conception?
Yeah.
Right.
When new DNA is formed, right?
Right. Exactly. So the philosophical problem, though, is it's ancient, and that is that which is in a state of potentiality is not in a state of actuality. So if it's in a state of potentiality, so in other words, it's the acorn in the oak tree. The acorn is not the oak tree. The acorn is it will potentially be the oak tree, but at the point of acornness, it is not an oak tree. At the point of cluster of cells, embryo, whatever, it is not baby at live birth. It is not even baby. It's not even whatever we want to call it, fetus in utero, second trimester, right? So that's a real hard element to work with. That aspect of potential versus actual.
Sure.
Right. I am potentially a millionaire, but I cannot actually be taxed like a millionaire.
Right. But you're not even on the progress to becoming one, right? Whereas this is without.
No, Colleen is.
That's fair. But like,
and we're married, so no.
But like, without doing any intervention from the outside,
right?
There's like a difference between potential, like, I'm bringing in like physics terms, potential energy and kinetic energy, right?
Right.
Where one, like, potential energy is when you have a rock standing on the top of a building. It has a potential to kill someone, but it's just sitting there. It's not going to do anything until you push it.
Right.
Whereas the rock that's already falling has potential, and it's currently using that potential.
Right.
So
this is the potential of the embryo is
well, there's a difference.
If it has a telos, it is going in a particular direction.
Yeah, an inevitable direction.
Right. And that's, it's all well and good, but you've got to, I mean,
like, you have to make the distinction because sperm and egg are potential, right? But that's a totally different kind of potential, because they aren't on their own going in that direction. Whereas once you get conception, then they are on their own going in that direction. I understand the difference between you've got the acorn and you've got the tree, but hey, the acorn has no water, it has nothing to like, it's the egg and sperm potential, not the sapling potential.
So it's basically it's let's put it this way: there's a general notion of potential versus actual, and then you're coming up with like a distinct notion of potentiality.
Yes, absolutely.
And that is to say that it has a particular trajectory, and in all likelihood, or 99.9% of the cases, it will come out in this particular way, if not obtruse. I guess the question then becomes, what does the second notion, the specific notion of potentiality, what does that do? There's a gap. What does that mean? What do I do with that? Where does the argument push me? So because its potentiality is directed and all conditions are in place, I'm missing a piece.
I think it follows that we're trying to determine what a person is, what personhood is, what a human life is. And if you follow a human life as far back as possible, that is the point that you arrive at, where there is undeniable certainty that is where they came from, right? And along that process, I think the argument is basically, there is no other undeniable point which you can determine they are a human or not. But that is one thing that you can say, is that they came from this point, and it hasn't been obstructed, and they become human because of that.
Right.
So basically, all of these other
Yeah.
aspects of trying to define it, like at birth, at the first trimester, at movement,
No, I'm with
at
you. No.
these other things have there's there's no grounding for them.
Yeah.
There's something, but it's not like concrete.
Mm-hmm.
It's just
I
the
get you on
concrete
that.
way. Yeah.
This is the one concrete element that its potentiality is directed toward a particular end and formation.
Mm-hmm.
I mean, the tricky part though is that it is still potential with this feature. So why is it that? So in other words, like it's.
Well, I think the argument is that it's not potential anymore. When you've determined that it, like.
No. But Christian, real quickly, but it's not. But it's not the cluster of cells is not a fetus. The cluster of cells at that point of being a cluster of cells is not a live baby.
Right.
So I'm with you on the. So in that sense, there's still potentiality. Understanding it's directed, but it's sort of like it's almost like if you were to just bracket it off at a point in time. Right. What is it? So so in that sense, it's potential.
Okay.
General.
Okay.
You with me?
Sure.
But I like your distinction because your distinction does actually sort of demarcate all of the acorns, right?
Yeah.
As it were, or the rocks on top of the buildings that don't have the directedness. I need to know what the directedness does to the potential that enables me to say it's a rights bearer.
Right.
That piece there is the tricky part. And I'm not saying I'm not thinking, you know, I mean, obviously you throw, and we can't do this at least scientifically, but you throw something like soul in.
Sure.
Right. You throw soul in with cluster of cells, then we've got a piece there in its potentiality to make it a rights bearer, as an example.
Right.
Yeah.
And that's not measurable, at least.
And exactly. So it's, yeah. But I, the whole element of the safe position I get, and the safe position being, hey, among all of the things that exist in the universe, well, most of us see that the human life has a certain dignity. And if you don't want to use that language, it ought to have a certain protection. So if I don't know what this is, and we're not just talking about, we're not talking about sort of like random atoms floating in space. We're talking about a human being. And so if it is a massive question mark in these early phases, but it could be a human being, as it were, the safe position also makes sense to me.
Yeah.
They're like, in other way, it's sort of, it's almost, well, actually it is sort of like Pascal's wager, right? It's like, I don't know if there's a God, but man, I'm going to, I'm going to sort of operate as if there is one on the off chance that there is one.
Sure.
I mean, it's one of the cheaper arguments, but nonetheless, you get the point. You wager, just not knowing that it is, on the off chance that you're wrong.
Which is not the position that the court takes, at least in the first trimester.
No, and that's why that's why I go back. Like, is there something? This almost reminds me of the one case that we dealt with, and I was like, is there some type of like legal term here that mandamus, right? From the mandamus case, I was like, what if he just used a different writ?
Right?
Could he have made some progress? It's not exactly like that, but are they bound to sort of a, there is legal argumentation that is such a thing, and are they bound to some, as it were, rules of legal argumentation or legal logic that would actually warrant their conclusion, even if you and I and others have problems with other pieces that are, well, I don't want to say secondary or tertiary, but that are relevant, but not the focus of the legal argument.
Sure.
Are you with me?
Yeah.
So in other words, sort of the state rights, these other pieces and therefore you're like, oh, I can see why they drew the conclusion that they drew, because they're working within this framework of legal argumentation. Yeah. You know, it's tricky.
Okay.
It's tricky, and I think that I think, you know, here's what I appreciate about it, is that I would hope that all the justices, including the dissenting, were as honest as they could be, and it wasn't just fueled by sort of politics.
Yeah.
My sense is that politics over the past 30, 40 years has gotten increasingly more polarized than it was. I think there was a little bit more bipartisanism in the past, in the 1900s, and I'd like to think that maybe the justices were also colored by that, as opposed to the justices now, which are also very polarized. So my hope is that they were honest in their intention, and I really do appreciate the historical sort of insights and pieces that sort of buttress their final conclusion, and that is to say, sort of like looking at how, whatever, within the human sweep of history, we just haven't been able to nail this issue down. And then, yeah, I mean, there's these other pieces as well that bother me, you know, like even just like rationally, not necessarily like so much morally, but just even rationally, like, you know, you make the decision, you know, you're still subtly saying or boldly saying something about what you're saying, what the embryo is in the first trimester without saying it.
Yeah, or they're saying it, what it means from a legal United States perspective.
Yeah.
They're not saying anything about anyone's personal morals or even the state's morals, because if we go to like their final conclusion, which is, we're looking at 163, 164, 165, they allow for the states to kind of determine different aspects of their conclusion. So what, I guess, is there anything we want to address in 163? I think in section 11 they kind of summarize and repeat it. A state criminal abortion statute of the current Texas type that accepts from criminality only a life-saving procedure on behalf of the mother without regard to pregnancy stage and without recognition of the other interests involved is violative of the Due Process Clause of the 14th Amendment. And then they state 3 subpoints for that. So for the stage prior to approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. So that's kind of a blanket statement. It's up to the medical judgment. The state has no vested, basically the state has no vested interest at that point.
Right.
But for the stage subsequent to approximately the end of the first trimester, the state, in promoting its interest in the health of the mother, may, if it chooses, regulate the abortion procedures in ways that are reasonably related to maternal health. And for the stage subsequent to viability, the state, in promoting its interest in the potentiality of human life, may, if it chooses, regulate and even prescribe abortion, except where it is necessary in appropriate medical judgment for the preservation of life and health of the mother. And then it says they can also define the terms of physician. So, it's interesting. And then there's only one other thing I wanted to mention, which is in the dissent, and that was on 172, which was, I think in section 2, or no, wait, where is it? I need to find this. Let me find it. Where I highlighted it. Oh yeah, right before section 2, the first paragraph of 172. Like they're talking about this hypothetical lawsuit, which was an interesting point that I wanted to bring up, because what he basically says, there isn't a way of knowing whether or not this. Okay, so in section 1, we know only that Plaintiff Rowe, at the time of filing her complaint, was a pregnant woman. For aught that appears in this record, she may have been in her last trimester of pregnancy and the date of the complaint was filed. And then, nonetheless, the court uses her complaint against the Texas statute as a fulcrum for defending the states. That states may impose virtually no restrictions on medical abortions performed during the first trimester. So they're talking about, like, hey, is this actually addressing the state or the issue at hand? And it references. The court departs from the long-standing admonition that it should never formulate a rule of constitutional law broader than is required by the precise facts which it is to be applied.
The one issue, like, I get that, right? And that's why the Doe, right? The Doe case was dismissed.
Yep.
It's tricky, though, when you're dealing with the process of the gestating embryo fetus. You know, when you're dealing with a process.
Yeah.
It's.
Yeah, and then also,
words, how the question would be, how do you deal with this? In other words, if it is a moral issue, if it is a legal issue, when is the right time to deal with this? Like early first trimester, and also too, cases are not heard immediately.
Yeah.
So that but unless I'm missing something that he's getting at.
So I think, like, if you just follow this, it's like, okay, well, a case is going to come up eventually, right? Where it's in the first trimester, and then it's going to have to go through this whole process again. So they are kind of looking forward to try to prevent it. But they also mentioned at the beginning of the majority opinion that because it's regarding pregnancy, it's different.
It's a special.
It's a special situation. Case because it has a timeline to it, and
I think Rehnquist, because he even says right there, even if there were a plaintiff in this case capable of litigating the issue, right? So even if that were the case, I would reach a conclusion opposite to that reached by the court, and then he jumps into privacy. So then the issue now becomes a debate between the majority and the minority or dissenting about exactly what should be included in the notion of privacy from the 14th Amendment.
Yeah.
That, you know what I'm saying?
Yep.
And he, it's yeah, and then he goes into the 14th Amendment, as we talked about before, the time of its adoption plus the laws against abortion at that time, and then that's another big piece of his argument. And then finally,
on 177,
I think so. This is the whole notion of, I'm sorry. I'm sorry. And then the other major piece of the argument is, I think the heart of it, though, is really privacy. And understanding the 14th. But then he also includes, your Texas law. Can you hear me?
Yeah, I can hear you.
Okay. The Texas law banned in toto, but Texas can apply it to later phases of pregnancy.
Yeah.
He saw as a contradiction. He saw as a problem. What did he say? The Texas statute was struck down in toto, even though the court apparently concedes that at later periods of pregnancy, Texas might impose these self-same statutory limitations on abortion.
Yeah.
My understanding of past practice is that a statute found to be invalid as applied to the particular plaintiff, but not unconstitutional as a whole, is not simply struck down, but is instead declared unconstitutional as applied to the fact situation before the court. I don't know. I feel like, isn't that an agreement? With a majority, because the majority is basically saying it wasn't absolute. But I guess
no. I think the result of the majority was that they struck down the Texas statute.
The law.
That's fair. He said they should just say it's unconstitutional and have Texas update it. Right?
Got it.
That's what it sounds like.
Yeah.
But yeah.
Oh, yeah. Instead, declared unconstitutional as applied. Wait a minute, is this really saying that particular law or all? Because he does a part for the whole argument. Well, wait a minute. Statute found to be invalid is applied to a particular plaintiff, but not unconstitutional as a whole, is not simply struck down, but is instead declared unconstitutional. Yeah, I think what he's trying to do here is he's trying to focus in on that if you're going to declare it unconstitutional, it's going to be you're going to declare that law unconstitutional. You're not. In other words, is there legislation going on here?
Mm-hmm.
Meaning, in other words, like by knocking down or by striking down the Texas statute, aren't you just striking down that particular statute? Shouldn't that be where the focus is, not on this is going to affect all other state laws as it relates to abortion? Do you know?
Yeah. I don't know.
I'm wondering. I'm not sure because I know he does another part for the whole argument, I think early on. Where oh yeah, here you go. Page 177. The court's opinion decides that a state may impose virtually no restriction on the performance of abortions during the first trimester of pregnancy. Skip down a few sentences. While a party may vindicate his own constitutional rights, he may not seek vindication for the rights of others. And I'm wondering there if that's what he's saying. Like, all right, fine, majority that I disagree with on this whole issue of privacy. You're not speaking for all. You're not speaking for all. You know, you were speaking for this particular case, and you were striking down that particular law. But why would this have any relevance to the other 49 states? You know?
Yeah.
I mean, that's what's going on. I mean, I'm sorry. That's what at least. No, I'm sorry. What's going on here is he is at least talking about. Well, I don't know. That's sort of weird. I don't know how you vindicate for the rights of one and not by extension the rights of others. Good place to stop as we're stumped and beautifully exhausted in this our longest session.
Indeed.
But it was one of the longest documents.
It was. It's a whole 66 pages.
Yeah, no doubt.
All right, I will wrap it up there then.